بسیار خوشحالم و ممنون از آقای آریان بهنامجو که دعوت ما رو قبول کردن. میدونم که این موقع سال شما سرتون خیلی شلوغه برای اینکه آخر ساله و همه چی باید رفاه بشه، ولی واقعا لطف کردید و ایشون تا ساعت 8:15 وقت دارن که با ما باشن. ولی اگه برنامهشون عوض شده و بیشتر وقت دارن و بیشتر به سوالا میرسیم، ولی سوفار که به من گفتن این بوده. You let me know عزیز. آقای آریان بهنامجو از دانشگاه University of California Hastings College of Law in San Francisco graduate شدن and Doctor of in the Juris رو در سال می 2019 گرفتن. با GPA بسیار بالا top 40 بودن در criminal concentrations, Hastings Constitution Law and Best Mood Court Oral Agreement رو honorable بردن. University of Southern California, Los Angeles, Bachelor of Art, Business Economy توی جون 2015 گرفتن, Sigma Pa Beta and Social Chairman بود. Experience-شون presently, he works with a very impressive law firm as called the West Coast Trial Lawyer in Los Angeles, California, downtown California. و ایشون litigation attorney هستن, handling a wide range of personal injury matter, including automobile accident, slip fall, premises liability and wrongful death claims, drafted complaints, motion letter petitions, discovery of clients in various jurisdiction throughout the state of California, and negotiated settlement with insurance companies on behalf of client, conducted deposition of a witness, and prepared case file for trial, mediation, and arbitration. توی سان فرانسیسکو پابلیک دیفندر بودند, توی کورت سرتیفاید لیگال اینترنشیپشون کردن که توی پریپیر کردن برای جاج. بعد it's similar to what I just said. و also توی Orange County Public Defender در سانتا آنا بودن 2018. And he had his legal internships, rights and appeals. And he also in University of California Hastings College of Law in San Francisco, research assistant to Professor and Academic Dean Morris A. Ratner Budan. And he surveyed the educational opportunity program offered by California state schools and drafted a memo comparing and contrasting them. And ایشون به زبان فارسی و انگلیسی هم میتونن بخونن و بنویسن. and هابیشون basketball and solo travel هستش. We're very very happy you're here. خیلی ممنون از دوستانی که به ما جوین کردن امشب. بعد آریان جان بفرمایید.
چشم. من سکرینمو شیر میکنم و بعد شروع میکنم.
مطمئنم که law is more difficult than medicine in America.
همه چی سخته. من به این نتیجه رسیدم که همه کار سخته. خب خیلی ممنون. شب همگی بخیر باشه. Thank you Dr. Madani for the very kind introduction. I'm going to speak mostly in English ولی سعی میکنم توضیحات لازمو here and there به فارسی هم بگم. همونجوری که دکتر مدنی عرض کردم من I'm a litigation attorney at West Coast Trial Lawyers and I represent plaintiffs all over the state of California who are the aggrieved or the injured party in a wide variety of cases including car accidents, wrongful death cases, slip and falls, premises liability, and some police misconduct cases which we're going to get into in a little bit. I'm excited to be here tonight and to speak with you all about the American legal framework and some general legal concepts to keep in mind before we discuss in more detail some areas of law that you're likely to encounter in your daily life including police encounters, work-related injuries, third-party negligence lawsuits, and so forth. I want to first start by explaining the basic structure of American law, because I think we all read and hear a lot of news concerning the law and legal cases, whether it's a new Supreme Court decision, like recently Roe versus Wade was overturned. I'm sure you're all aware of that. Or whether it's a controversial law that was passed in Florida or some other state in the United States, and also lawsuits and criminal charges brought against celebrities or public officials. So I thought it might be beneficial to you in terms of helping you better process the information you read and hear by going over the structure of US laws, as well as the difference between civil and criminal cases. So please bear with me through this initial introduction, if you will. After that, we're going to talk about the Fourth Amendment violations in the context of police stops. Very interesting stuff. And I have some pop quiz questions as well that I'm excited to go over with you guys. And different types of injury cases. And lastly, I'm going to leave you with my most important recommendation at the end when we discuss uninsured or underinsured motorist coverage. So structure of US laws, obviously we have the United States Constitution, which is the supreme law of the land and the source of many of our rights and freedoms that we experience on a daily basis. No federal or state law can violate the US Constitution. So for example, if a state or the US Congress for that matter passes a law, also known as a statute, that is in conflict with the US Constitution, it's going to get challenged and stricken by the courts as unconstitutional and therefore invalid. And in general, the first 10 amendments, known collectively as the Bill of Rights, offer specific protections of individual liberty and justice, and they place restrictions on the powers of government. Obviously, we're all familiar, or at least we've heard about the First Amendment, freedom of speech, freedom of religion, the Second Amendment, which is highly controversial, the right to bear arms or guns, and the Fourth Amendment, which protects us against unreasonable searches and seizures, and the Fifth Amendment, due process rights, and the privilege against self-incrimination. So the second source of law is state constitutions. Each state has its own constitution, and they can also provide rights and liberties to their citizens beyond what the US Constitution offers. So I mentioned Roe versus Wade, and obviously that recently Supreme Court overturned that decision after a very long time and said that there's no constitutional right to an abortion. So right now what California is doing is they're amending the California state constitution to explicitly cover abortion and for the right to abortion and contraceptions. So obviously not every state's going to do that, but the point is state constitutions can give you additional rights and liberties as long as it's not in conflict with the US Constitution. And in this case, it's not, because the United States Supreme Court has just said that there's no constitutional right to an abortion. It doesn't mean that if a state provides that right to its citizen, that that's unconstitutional. And the same US Constitution is what sets up our system of government, which is what enables Congress to pass laws, which are called statutes, regulations, and at the local and state level, those are called ordinances. And the last one is quite important. And the reason I wanted to go over all of this information with you guys is because case law is where the Supreme Court of the United States comes into play. And that's where we get a lot of guidance as to what the Constitution actually protects. So the American system is the common law system. We adopt this from England to the extent that it was consistent with the newly found Constitution. But it basically consists of rules of law that come from written decisions of judges who hear and decide lawsuits. So when a judge decides a case and publishes the decision becomes what we call precedent for future litigation. And this is why the Supreme Court of the United States is so important, because whenever a law or decision by government authorities gets challenged in court, it usually goes all the way up on appeal to the Supreme Court. And their job is to apply and interpret the Constitution. But the Constitution is very general and vague. For example, the Fifth Amendment Due Process Clause just says, quote, "No person shall be deprived of life, liberty, or property without due process of law," end quote. That's all it says. Well, what does that actually mean in terms of our daily life or the rights that this actually provides us? So that's what the Supreme Court does. When these challenges go all the way up there, they come out and essentially define standards or explain what it actually protects in a given circumstance. So we're going to be going through some case law, but I just want you guys to understand that the nexus is the Constitution, but really the Supreme Court is responsible for telling us what the Constitution means and how it protects us. And the reason that this is important to understand as well, that some justices are the 9 judges that sit in the Supreme Court, have different opinions is because each of them has a different way of analyzing the Constitution. Some of them are very textual. They look at the text and they say, this is what the text says. It's very strict. And some of them look at the structure of the Constitution. For example, Roe versus Wade that was overturned. What the justices are saying is that, well, let me backtrack for a second. So that same provision of the Constitution that says no person shall be deprived of life, liberty, or property without due process of law, that's what the Supreme Court derived the right to abortion from in Roe versus Wade, right? They did some legal engineering to say this actually means you have right to abortion. So what the conservative justices on the Supreme Court are saying is, no, we can't just make this right. We don't have the power as a court. This is something that Congress needs to legislate. Congress needs to provide these rights to the people. So it's a structural argument. They're saying this is not our duty. It's the structure. It's the duty of Congress. And people need to elect the right officials to go and get what they want done. So that's a structural way of looking at the Constitution. Okay, I'm going to go into my next slide here. Civil and criminal. I hear this come up a lot. I know there's some confusion about when a case is civil, what cases are criminal. So we're going to go over the basic terminology here. Civil lawsuits are called lawsuits, first of all, and they're initiated by either private persons or private companies against other private parties or companies. And in some cases, you can also sue the government in a lawsuit as well and allege harm. For example, when a government employee is negligent and their negligence causes harm to somebody, we can also sue the government for damages. The terminology in a civil case is always plaintiff versus defendant, whereas in a criminal case, it's always the people of the state. In California, it's either the people of the state of California versus the criminal defendant. And the reason for that is the different purposes. In a civil case, the purpose is either to get money damages, or you're going to courts and you're asking them to order someone not to show up at, within 20 yards of your house. That's called injunctive relief. Or in some cases, you want the court to declare, so you're seeking declaratory relief that a certain law is unconstitutional. Whereas in a criminal case, the purpose is to punish the person that committed the crime and to deter other people from committing crimes by giving a sentence to someone who's done something bad or messaging to society that you shouldn't engage in this behavior because if you do, you're going to be locked up. So the terminology that we frequently hear in criminal cases is guilty, right? Acquitted, innocent, convicted, felony, misdemeanor. And in a civil lawsuit, when somebody wins, that's called, the defendant is held liable. That's the terminology that we use. We don't say convicted or guilty in a civil case. One of the other big differences is the standard of proof. This is a big thing to understand. In a civil case, the standard of proof is called preponderance of the evidence, which means that you need to prove your claims by more than 50%. So if a jury is convinced 51% that what the plaintiff is saying happened, that's good enough. You don't need to 100% convince the jury. As long as it's more likely than not. More likely than not means just a little bit more than 50%. On the other hand, in a criminal case, the burden is quite high. So the government, when they're prosecuting you, either state prosecutors who are called district attorneys, or you have U.S. attorneys who are federal prosecutors, and they prosecute for federal crimes. They have to meet, their burden is beyond a reasonable doubt. And I'm sure many of us heard that in movies and TV series. And that's a very high burden. It means that basically it's just over 90%. If you want to think about it in percentage terms, the jury has to be that convinced that the person who's standing trial has committed that crime. Otherwise, you can't return a guilty verdict and throw them in prison. And it makes sense, right? Because in a criminal case, we're taking away someone's freedom. وقتی آزادی یک کسی روی لاین باشه، قاعدتاً بعد institutional protection های بیشتری داشته باشیم و beyond a reasonable doubt یکی از این institutional protection ها هست. دو تای دیگه که هست که میخواستم اشاره بکنم کیس هایی هست و اینجا میبینید که مهم بودن سپریم کورت و کیس لا. ببینید توی کیس بریدی versus مریلند که اینجا هایلایت کردم، تو این کیس توی سال 1963 سپریم کورت آمریکا اومد توضیح داد که خب کانستیتوشن، قانون اساسی داره میگه که شما دو پروسس رایت داری و یه سیکس امندمنت رایت به فیر ترایل داری، یه ترایلی که عادلانه باشه. بنابراین اگر دادستان اینفورمیشنی داره که کمک میکنه به مدافع، این کسی که کریمینال دیفندنت هست، مثلا میدونه که واقعا اون کارو، اون جرمی که متهم شده رو خودش انجام نداده، یه کسی دیگه انجام داده، خب این دادستان وظیفه داره، یعنی کانستیتوشن requires it که این اطلاعات رو به سمت مقابل بده. این فقط تو کیس های کریمینال هست و اینجا میبینیم که چجوریه که سپریم کورت دائما داره تعریف میکنه که این قانون اساسی یعنی چی، یعنی given set of facts وقتی که مواجه میشیم اون موقع این کیس ها میره بالا و سپریم کورت میگه که آره تو این سیچویشن اینجوری باید عمل بکنن پلیس یا دادستان in this case باید اینجوری عمل بکنه. و قبل از 1963 استیت ها، یعنی اگر فرضاً استیت of کالیفرنیا شما رو برای DUI یا برای جرم دیگه پروسیکیوت میکرد، لازم نبود که برای شما، اگر شما نمیتونستی پول وکیل بدی، برای شما وکیل بگیرن. ولی تو سال 1963 اومدن گفتن خب قانون اساسی میگه شما you have a right to a fair trial. چجوری ما میتونیم یک کسی که نمیتونه پول وکیل بده و از خودش دفاع بکنه رو بیایم محاکمه بکنیم و بندازیم تو زندان و این بگیم که اوه خب این فرد has a right to a fair trial. هم چیزی نمیتونه باشه. بنابراین مجبور کردن تمام استیت ها رو و قانون دونستن که هر استیتی بیاد و به کسایی که نمیتونن از خودشون دفاع بکنن و پولشون ندارن براشون وکیل تعیین میکنن و این وکیل ها اسمشون پابلیک دیفندره که از سال 1963 به بعد تو تمام استیت های آمریکا پابلیک دیفندر آفیس درست کردن و وکیل های خیلی خوبی هستن، دائما ترایل میرن و از آدمایی که متهم به جرم شدن و پولشون ندارن که وکیل بگیرن دفاع میکنن. Okay, so that's with criminal and civil. حالا توجه بکنیم به Fourth Amendment of the United States Constitution. This is the amendment that protects us from, let me change the screen as well. Here we go. اگه همه بتونیم بخونیم, that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. خب این خیلی جنرال و عامیانه است. یعنی واقعا در زندگی روزمره وقتی پلیس میاد و با ما شروع میکنه صحبت کردن یا ما رو میزنه کنار، این یعنی چی؟ دقیقاً چه جور پروتکشنی ما داریم وقتی که با پلیس مواجه میشیم. So it's obvious that when the police arrest us that a seizure has occurred. It's very obvious, right? They take us, they put us in handcuffs, they've seized us. And if they come and search our house, then obviously that's a search as well. But what I want to explore with you guys tonight is, what other situations are there that could constitute a seizure within the meaning of the Fourth Amendment? And what other situations are there that constitute a search that are not just searching your home? و این قانون خیلی قانون جالبه. این exclusionary rule، من اصلا یکی از دلایلی که واقعا به کریمینال لا آمریکا خیلی علاقه‌مند شدم این قانون exclusionary rule. این قانون میگه که اگر پلیس Fourth Amendment رایت شما رو وایلیت بکنه، یعنی بدون probable cause ماشین شما رو بیاد بگرده یا خونه شما رو بگرده یا حتی خودتون رو بگرده و شما رو هم ارست بکنه، این اویدنسی که اینا به دست میارن، حتی واقعا اگر اویدنس باشه که شما مرتکب به جرم شدید، حالا یا کش الیگاله یا دراگز، خیلی چیزای مختلف میتونه باشه، برای اینکه شما رو پروتکت بکنن این قانون exclusionary میگه this evidence needs to be suppressed. So اولین کاری که یه وکیل جنایی توی آمریکا میکنه، یه وکیل خوب، اینه که بیاد ببینه که شما آیا Fourth Amendment رایتتون وایلیت شده یا خیر. و جوری که این کار رو انجام میدن این که همیشه سوال اول اینه که have you been searched or seized? And if the question to that is yes, then that means that they need to have probable cause or some other justification. And the third question is, okay, if there was probable cause, then was there a warrant or was there an exception to the warrant requirement? Okay. و یه مثال میزنم اینجا که قشنگ متوجه بشین منظور من چیه راجع به exclusionary rule. فرض مثال اگر یه پلیس بیاد که خونه شما رو بدون وارنت بگرده و اویدنس پیدا بکنه که حالا شما یه داروی غیر قانونی دارید یا هر چی و بخوام بر حسب اون اویدنسی که کسب کردن شما رو پروسیکیوت بکنن، شما وکیل جناییتون میاد میگه که wait a second شما you didn't have a warrant when you searched the home. بنابراین این فورس غیر قانونی که پیدا کردین رو باید سپرس بشه. سپرس یعنی چی؟ یعنی نمیتونن توی کیس علیه شما اینو نگه دارن. بعد اویدنس رو میندازن دور. انگار مثلا واقعا این اویدنس کسب نشده. یعنی ندیده میگیریم، چشم‌پوشی میکنیم و خیلی از مواقع این باعث میشه که کیس اصلا از بین بره. درسته؟ چون اگر اونا اویدنس اصلی کیس نداشته باشن اصلا کیسی وجود نداره. و این کارو کردن که پلیس deter بشه, discourage بشه from violating your constitutional rights. And this is the only way that they can remedy your rights if they've been violated. و یه بخش دوم این قانون is called fruit of poisonous tree. تو همون مثالی که زدم شما حدس بزنید که یا فرض بکنید که پلیس میاد توی کشوی کیچنتون، آشپزخونه‌تون یه نامه پیدا میکنه و توی این نامه یه آدرس خیلی دقیق هست و یه سیفتی باکس و یه کلید و پلیس پا میشه میره بانک، این سیفتی باکس رو باز میکنه و اون تو مثلا $100,000 کش پیدا میکنه. این اویدنس هم باز باید سپرس بشه. یعنی چرا؟ چون این بهش میگن fruit of the poisonous tree، یعنی از اون اویدنس الیگال اولیه، چون از اول غیر قانونی وارد خونه شما شدن و از اون سرچ الیگالی که کردن این اطلاعات رو به دست آوردن، این اطلاعات هم پویزنسه، یعنی تینتده و این هم باید سپرس بشه. سو برای همینه که خیلی مهمه که آدم Fourth Amendment رایتش رو خوب بلد باشه که الان we're gonna get into it که خدایی نکرده یه همچین حادثه اگه واسه آدم پیش بیاد آدم بتونه بر حسب Fourth Amendment اویدنسی که کسب کردن suppress بکنه. So seizure of a person. Obviously there's a seizure of property as well, but we're going to focus on seizure of the person tonight. Here we go. قانونی که Supreme Court اومده توضیح داده میگه a person is seized if in view of all the circumstances surrounding the incident a reasonable person would have believed that he or she was not free to leave. So the reasonable person, first of all, presupposes someone innocent and somebody who knows their rights very well and isn't very intimidated by police easily. So for example, if the police come up to you and they start asking you questions, that by itself does not constitute a seizure. Even if you internally feel the pressure not to be able to walk away and not answer their questions, that doesn't mean that you're seized, because a reasonable person would not think that the police just coming up to them and asking them the question constitutes a seizure. Vali, if they use use of force, if their tone of voice is very serious, if they demand you to submit and stop, or otherwise use threatening behavior, if they pull a gun out at you and surround you and tell you you can't go anywhere, then you've been seized within the meaning of the Fourth Amendment, because clearly a reasonable person would not feel that they were free to leave. And I've stated these examples here in this slide. It says threatening presence of several officers, display of weapons, some physical touching of the person or citizen, or the use of language or tone, or voice indicating that compliance with the officer's request is mandatory. In the absence of this evidence, otherwise inoffensive contact between a member of the public and the police cannot amount to a seizure. Slide بعدی. So هر موقع که پلیس شما رو pull over بکنه برای suspicion for speeding or DUI or whatever, running a stop sign, that's a seizure, right? Because they're turning on their flash and they're maybe even speaking out of the walkie-talkie telling you to pull over. And that requires them to have reasonable suspicion that a person is or has committed a crime. And crime, of course, refers to very serious things like murder and things like that. But technically, speeding tickets and all of that stuff are infractions. It's a type of crime. It's a very low-level crime. But if they see you speeding or running through a stop sign or something like that, that gives them reasonable suspicion to pull you over. So that's not quite an arrest. Because it's not an arrest, it's a lower standard that they need to meet to just pull you over. It's called an investigative detention. And those are situations that we're likely all might encounter or have encountered. And it's important to know what your rights are if you're ever in that situation. So اینجا یه مثال زدم برای همه. اگر حالا مثال بلند میخونم و اگر بتونید حدس بزنید ببینید که کدوم answer به نظرتون درسته با توضیحاتی که من دادم. شاید ببینیم توضیحات چقدر خوب بوده یا خیر. Detective Rahimi sees a woman she suspects of carrying illegal drugs in her backpack. Detective Rahimi approaches the woman, identifies herself, and says, "Mind if I look in the backpack?" The young woman agrees, and Rahimi searches it. Has a seizure of the person taken place, as the term is used in the Fourth Amendment law? So how many people think yes, because there was a physical restraint, B, no, and C, yes, because the suspect submitted to the authority of the officer? Who thinks it's A? If I could just get a show of hands. Okay, a lot of people don't have their cameras, but the answer to this is no. The answer to this is no, because the officer is saying, mind if I check your backpack, right? It's not saying, you know, I need to check your backpack. So this is a way where it's very tricky, right? Police will oftentimes try to come up to you and get your consent to do things that they otherwise don't have justification to do. So this would not be a seizure, even though most people would feel very uncomfortable saying no to the police officer who's saying, hey, can I check in your backpack? Most of us wouldn't feel comfortable saying no. And what's important to understand is نگفتن نمیتونه باعث شکاکیت بشه. یعنی این قانون اساسی سوپریم کورت گفته که شما وقتی بگی نه، اونا وقتی دارن درخواست کانسنت میکنن، این نمیتونه شکاکیت اینا رو ایجاد بکنه. شکاکیتی که لازم دارن که واقعا خودشون با فورس این کار رو انجام بدن. ولی خیلی مهمه که آدم بدونه که fact of refusal با manner of refusal خیلی فرق میکنه. یعنی اگر شما خیلی محکم و مصمم بگید نه، این نمیتونه شکاکیت ایجاد کنه. ولی اگر شروع کنید عرق کردن، شروع کنید دویدن یا همچین چیزی، خب این شکاکیت لازم رو بهشون میده که فکر کنن شما واقعا یه کار غیرقانونی کردید و بر حسب اون نگرتون دارن یا جیبتون رو بگردن یا ماشینتون رو بگردن، که حالا به اگزمپل ماشینم میرسیم. مثال دوم هم زدم اینجا براتون. The facts are the same. Officer Hill sees a woman he suspects of shoplifting, approaches the woman, identifies herself, and says, "I need to look in your backpack." Without a word, the woman hands the backpack over. Has a seizure of the person taken place? This one, the answer is yes, right? Because the suspect submitted to the authority of the officer. When the police officer says, "I need to look in your backpack," it means you need to comply with my request. So this is how the Fourth Amendment can apply to a daily situation with the police and a member of society. Next, we've talked about seizures. So the Fourth Amendment protects you against unreasonable searches and seizures. If the police want to pull you over, they need either probable cause that you've committed a crime. Probable cause means there's fair probability that you've committed a crime. And reasonable suspicion is a lower justification that they need to just pull you over for an investigative stop and ask you a few questions and see what's going on. Reasonable suspicion just means, they have a reasonable basis to believe that you might be committing criminal activity. So the standard to be able to just pull you over for a second and talk to you is much lower than them actually placing you under arrest. So that's seizures. It includes arrests and in some cases, police questioning, depending on the circumstances. Searches is the other aspect of the Fourth Amendment. And obviously when the Constitution was adopted, usually the government could only search your person or your house. But as society progressed and technology developed, things got a little bit more complicated. And so the Supreme Court had to step in and articulate a new standard for what a search is. So in 1967, in a famous decision called Katz versus United States, the Supreme Court held that a search occurs under the Fourth Amendment when a governmental employee or agent violates an individual's reasonable expectation of privacy. And each of the numbers that I have here, these are all came out of different types of cases where in the first case, the police or FBI had wiretapped someone's phone. And that's when actually this decision occurred because at the time, they hadn't trespassed into the defendant's home to obtain that information. So they had to articulate this new standard and say, well, when you're talking on the phone, you have a reasonable expectation in your house, you have a reasonable expectation of privacy. So yes, that's a search. And if it's a search, that means you need a warrant supported by probable cause. However, if your friend that you're talking to is secretly recording a conversation that you're having with them, you might have a reasonable expectation you might have an expectation of privacy, which is subjective, but it's not reasonable. Anytime you communicate with other outside parties, you're risking that, they might go report or record you. And that's not a search within the meaning of the First Amendment. So if, your friend wanted to record a conversation with you and you were saying something incriminating, something that could show that you were conspiring to commit a crime, you can't later on say, well, this statement needs to be excluded because you violated my Fourth Amendment, right? Because no search has occurred. So we don't need to get into the analysis of, okay, was there probable cause? Was there an warrant, or was there an exception to the warrant requirement? The other big one here is obviously inside your house, the Fourth Amendment protection is at its strongest. Also curtilage, number 7, that refers to the close area around the house. You also have a reasonable expectation of privacy there. You don't have a reasonable expectation of privacy in your garbage that you leave out on the street. Even though you don't have any viable alternatives, there's nothing else you can do with trash. If you're leaving incriminating documents and stuff like that, and the police go through it and find something, you won't be able to bring a motion to suppress to exclude it on the basis that they did not have a warrant. And dog sniffs are also considered searches depending on where they occur. If it occurs in a home or the curtilage, the area right around the home, it's an envelope that protects the home, then that's also a search that needs to happen with probable cause and a warrant. But if they're just doing a dog sniff in the airport or even during the course of a traffic stop, then that's actually not a search that they need justification for. So this is probably the most important area of criminal law that I want to go over with you guys tonight. The Supreme Court has said that, yes, you have a reasonable expectation of privacy in your car. And if the police search it, they've committed a search within the meaning of the First Amendment. But all they need to search your car is probable cause. They don't need a warrant. And what happens a lot of times is you might get pulled over for speeding, right? Or running a stop sign. And when that happens, the suspicion is that you've either speeded or you ran the stop sign. So if the police come up to you and for whatever reason they have a hunch, they just have a sixth sense, they think they might find something in your car, they might ask you, can I search your car? Most people think that they have to say yes to that. But what the police are trying to do is they're trying to get your consent so that we don't have to worry about reasonable suspicion and probable cause. They don't need to establish that. They're trying to get your consent, and this is how 80% of car searches occur. The officer just asks, and people usually say yes. So, and here's the thing, the police don't need to tell you that you have a right to refuse the search. If they tell you, that's just one factor in determining whether your consent was voluntary, right? If the police, for example, hold a gun at you and they say, can we search your car? Then you could say my consent was not voluntary. But most of the time, this is what police do. They're very sophisticated. They know what they're doing. They don't want to run into challenges down the line where the evidence that they've obtained gets suppressed. So they'll come up to you and just ask you if they can search your car. And I just want you guys all to know that if you were pulled over for speeding or running stop signs, something that doesn't have to do with driving under the influence, you have every right to say no. And because the probable cause, they're not likely to find evidence of the crime in your car. اگر شما برای speeding you're running a stop sign pull over شدی، هیچ دلیلی برای سرچ کردن ماشین شما وجود نداره، درسته؟ ولی اگر پلیس ببینه که خب شما داشتی یه ذره سورو می‌کردی، خیلی یواش می‌رفتی، یه جا خیلی تند می‌رفتی، بعد میاد می‌بینه استاپتون می‌کنه، بعد که میاد می‌بینه خب بوی الکل میدید، شاید چشاتون قرمزه، اون موقع است که خب اوکی الان یه سسپشنی وجود داره که شما شاید مشروب خوردید و بر اون اساس میتونه بیاد، الان probable cause داره که they might find you know an open container of alcohol، یعنی یه بطری مشروب تو ماشینتون شاید پیدا بکنن و بر اون اساس میتونن ماشین شما رو بگیرن. ولی در غیر اون صورت وقتی که فقط برای speeding یا یه چیز دیگه که it's a traffic stop, it's a traffic violation pull over شدین، you have no obligation to say yes you can search my car even if you feel that's uncomfortable or you feel like that's going to make you more suspicious. بر حسب قانون نمیتونن اینو به عنوان شکاکیت استفاده بکنن. and خیلی از کیس ها بوده که پلیس یک کسی رو pull over کرده برای traffic violation، فرضاً headlight، یکی از headlightاشون کار نمی‌کرده و سوال میکنه میگه که does the trunk open and تو اون situation the court found that despite cop با اینکه پلیس بهش نگفته بود که میتونی reject بکنی request منو، that was a constitutional search because the client, or excuse me not the client, the defendant had consented to the search. So that's a good thing to be aware of, and I'm not saying be a smart ass, so to speak, with the police, but certainly it's good to know your rights so that if you do have something in your car that for whatever reason you don't want to expose to a search, then you could just tell the officer, well, what's your probable cause? You know, I was speeding. You know, what evidence of speeding are you going to find in my car? You can very politely say that and let the cop know that you understand your rights. یه مثال دیگه زدم. So Castro is pulled over for speeding by the police. Police officer asks Castro if he can search his car. Castro says no. The police officer asks Castro to step outside the vehicle, searches his car, and finds illegal marijuana in the dashboard. Was this a lawful search? So I don't know if the people who have their cameras on, who thinks this is a lawful search? If you could put your hand up. Okay. So this is not a legal search because there was no probable cause that you'll find evidence of speeding in the car, and Castro didn't consent, right? So there's no justification to search in the car. You either need consent or independent probable cause, none of which existed in this case, okay? Same example. Here we go. So this time, they pull him over for suspicion of driving under the influence because he swerved into another traffic lane a couple times. Police officer noticed that Castro's eyes are bloodshot, strong odor of alcohol emanates from his person and vehicle. Castro does not give the police officer consent to search his car. Regardless, the police officer searches Castro's car and finds illegal marijuana in an open container of alcohol under the driver's seat. Was this a lawful search? And the answer here is yes, because yes, even though Castro didn't consent, the cops had probable cause. They wouldn't have had probable cause just based on the swerving, right? That could be because you're on your phone or otherwise distracted. But when they came up to Castro and they saw that he smelled of alcohol, his eyes were red, then that gives them that there's a fair probability that he's driving under influence, and they might find an open container of alcohol or marijuana in the car in which they did. So it doesn't matter that Castro didn't consent because the cops had probable cause. So this is تقریبا آخر کیس‌های جنایی هستیم و اگر هر موقع تو این سیچویشن قرار گرفتید these are the main things to know. So اگر شما پولوور میشید روی به هر دلیلی، حالا یه دقیقه لینتون رو عوض کردید، فلاشرتون رو نزدید، وقتی که پلیس از شما درخواست میکنه که توی برترلایزر چیز بکنید، نفس بکشید که ببینن blood alcohol contentتون چیه، you have no obligation to do that, okay? و نباید هم بکنید. I recommend not to do it if you've in fact been drinking, and you also don't have to do the field sobriety test که میگن صاف را برو، این کارو بکن، این کار مختلفی که بهتون میگن بیرون از ماشین انجام بدید، اونا رو هم you have no legal obligation to do because the police need probable cause. So if you blow into the breathalyzer or do the field sobriety test, you might actually be giving them the probable cause to arrest you for driving under the influence. چون برخی موقع شاید حدس میزنن که شما شاید درینک خوردید، یه مقدار شاید باز هستید، ولی probable cause ندارن. یعنی اگر بیان شما بو نمیدی، you seem kind of fine, they can't really arrest you at that point. ولی اگر شروع بکنی این کار رو انجام بدن، ممکنه که probable cause develop بشه و بعد اون حس بتونن arrestتون بکنن. ولی اگر فرضاً مثلا پلیس دیدش که شما از یه رستورانی تلو می‌خوردین، اومدین بیرون، هم موقع سوار ماشین شدید و هم موقع پول اوورتون میکنه برای arrestتون میکنه، then they already have the probable cause and you do have to submit to a mandatory blood or breath test. و اگر خدای نکرده تو همچین سیچویشنی قرار گرفتید، بهتره که breath test رو انجام بدید، چون breath test به دقیقی blood test نیست و ممکنه که خیلی blood alcohol contentتون رو پایین‌تر نشون بده که could be better for you down the line، که مثلا بگین خیلی باز نبودین یا اصلا باز نبودید، hopefully که اون موقع زیر 0.008. و اگر refuse at that point, if after you've been placed under arrest, if you refuse to give a breath test or let them take your blood, میتونن برن یه warrant بگیرن و با حالت اجبار خون بگیرن ازتون و اگر لازم بشه که این کارو بکنن you might face additional penalties as well، مثل legal monetary fine، driver's license یه سال revoke میشه و اگر کیس جنایی بره و محاکمه بشید و guilty باشید ممکنه که mandatory sentence هم بهتون بدن، یعنی اونجوری نیست که شما بگین I'm going to go community service انجام میدم به جاش. نه، اگر کوآپریت نکنی با پلیس بعد از اینکه arrestتون کردن واسه DUI خیلی براتون میتونه سنگین تموم بشه. ولی یادتون باشه که اگر خدای نکرده این اتفاق افتاد با breath test breath test رو انتخاب بکنید. قانون آخر اینه که if you're arrested you have a right to remain silent and you have a right to an attorney. So اینو تو همه فیلم ها میبینید که وقتی یک کسی arrest میشه بهش میگن که you have a right to remain silent, anything you say can and will be used against you in a court of law, and you have a right to an attorney. If you can't afford one will be provided for you. مهمی این قانون اینه که بعضی فکر میکنن که اگر هیچی فقط نگن they're invoking their right، یعنی پلیس نمیتونه ازشون سوال بکنه because they're saying I have a right to remain silent. ولی the issue with the right to remain silent, the right to attorney is you have to unambiguously invoke it. And once you do that, it terminates the interrogation. So شما فرضاً اگر برای DUI arrest بشی و میبرتون پلیس استیشن شروع میکنن توی اتاق از شما سوال کردن، شما به هیچ عنوان نباید صحبت بکنید. یعنی حتی اگه احساس کنید که میتونید اینسنس خودتون رو پروو بکنید یا هر چی، اصلا به هیچ عنوان نباید با پلیس بدون وکیل صحبت بکنید و هر چقدر اونجا ساکت بشینید اینا میتونن ادامه بدن سوالشون رو. شما باید علنا بگین که I'm invoking my right to remain silent. به محضی که شما این حرف رو بزنید اونا باید سوال کردن رو تموم بکنن، از اتاق برن بیرون و دیگه نمیتونن با شما برخورد بکنن تا اینکه یه زمان خیلی خاصی بگذره، معمولا 2 روز، یا اینکه وکیل بگیرید و از طریق وکیل با شما صحبت بکنن. Your right to an attorney هم همینه، یعنی شما ممکنه وکیلتون متوجه شده که شما arrest شدید و سریع اومده به دادتون برسه و شاید هم پلیس استیشن باشه و میخواد بیاد تو اتاق ولی نمیذارم بیاد تو اتاق. شما باید بگی که I'm invoking my right to an attorney. به محض که این حرف رو بزنید پلیس باید سوال کردنش رو تموم بکنه و بذاره که وکیلتون بیاد و از طریق وکیل باتون صحبت بکنه. ولی مشکل اینه که پلیس معمولا میخواد از شما کنفشن بگیره، بنابراین نمیاد قشنگ توضیح بده این چیزا رو که بهتون بگه او خب اگه میخوای بگی که you want to remain silent just let us know. نه، سعی میکنن کنفشن از شما بگیرن که دیگه خر از پل میگذره و برای همین خیلی مهمه که هر موقع اگر تو همچین سیچویشنی قرار گرفتین یا فامیلی ممبرتون خدای نکرده بچه‌هاتون، نوه‌هاتون، اینه که خوب بدونن این قانون اینه که باید بگی علنا I'm invoking my right to remain silent یا اینکه I'm invoking my right to an attorney. So بحث کیس‌های جنایی رو دیگه تموم میکنم اونجا. من فکر کنم که that covers most of what we need to be worried about potentially in a given situation. کیس‌های civil یا personal injury چند تا فرم مختلف داره. اگر شما توی کار لطمه ببینید یا اینجور بشین احتمالاً it's a workers compensation claim، مگر اینکه یه سوم شخصی شما رو چیز بکنه، اینجور بکنه، مقصر باشه. اون موقع you have both the workers compensation claim and a third party claim which is going to be a personal injury lawsuit against the third party that was negligent. And there's also medical malpractice cases. I put that in there because I know there's a lot of doctors in the crowd tonight, so we'll talk a little bit about that as well. So California has a no-fault workers' compensation system, which means that you don't have to prove that the employer was at fault in any way for the employee getting injured for the employee to get workers' compensation benefits. And actually, the California Constitution says that there's a right to workers' compensation benefits. So this is a basic right, and all employers, I'm sure there's some employers in the crowd, need to have workers' compensation insurance. If you don't, you could be subject to civil and criminal liability. So you don't need to establish that the employer was at fault for any way for the employee getting injured. as long as the employee is performing services that arise out of employment and is acting within the course of employment, you can make a workers' compensation claim. So those are really the only two conditions. And essentially that means that, you didn't intentionally hurt yourself, right? Because if you're intentionally hurting yourself, that's not arising out of your employment. But if, for example, you're a FedEx driver and somebody T-bones you, runs a stop sign, hits you, obviously you're performing your duties as a driver, and you were in the course of employment as well. So you have a workers' compensation claim. You also, and we'll get to this a little bit later, have a personal injury claim against the at-fault third party. And there's some situations that aren't covered here. For example, if an employee starts a fight with another colleague and gets injured as a result, that's not going to entitle them to workers' compensation benefits. And some recreational stuff, if your employees are playing soccer once a week or something and they get injured there, then that's not going to be covered by workers' comp unless you made it a condition of employment and they have to show up because you wanted that team building or something like that. But generally speaking, if you get injured doing a recreational sport with your colleagues, that's not going to be workers' comp. This is probably the most famous workers' compensation rule, the going and the coming rule. And it essentially says that when an employee is commuting to work and going home from work, that they're not in the course of employment. So if they get injured during their commute to work, they don't have a workers' compensation claim. The rationale for this is that when you're commuting to work, the employee is not really conferring a service or benefiting the employer, and the employer is vice versa not getting a benefit from the employee making the commute, so they shouldn't have to be responsible for this. There's some notable exceptions here that are good to keep in mind. For example, if the employer pays for the commute, before COVID, a lot of attorneys had to, drive long distances for depositions, and the law firm will usually pay for that commute, for your gas and so forth. And so in a situation like that, if I'm on my way to a deposition and I get into a car accident and it's someone else's fault or not, I have a workers' compensation claim that I can make with my employer. The required vehicle exception is when basically it's an implicit condition of your employment. If you require your employees to travel from one place to another pretty frequently, and you don't provide the transportation with your own car, then that's going to be considered within the course of employment. And they can also bring a workers' compensation claim. It's important to understand that workers' compensation claims are not lawsuits. So you can't sue your employer when you get injured on the job. You just make a claim with the workers, with your employer, and the employer makes a claim with the workers' compensation insurance company. So the benefits in a workers' compensation claim are pretty limited. So they'll pay for your medical treatment. Obviously, you got to go to a doctor that's within the network of providers. And if you're injured for some temporary period of time, or you can't go to work for, say, let's say a couple months, then they'll pay 2/3 of your lost income. So every week they see what is 2/3 of what you were normally making, and they'll make that payment to you on a weekly basis. And if God forbid you have a more serious injury and you're considered permanently disabled, so they'll wait some period of time, and if they see after some time your condition has stabilized and further improvement is unlikely, then you're going to be considered permanently disabled. And there's two types of permanent disability. One is partial permanent disability, and the other is full permanent disability. And the disability is essentially rated on a scale of between 0 to 100% through the permanent disability rating schedule. I know there's some doctors in the crowd, maybe you have experience diagnosing patients who were injured on the job and assigning a percentage disability to them. But if you're found to be permanently disabled, they'll give you essentially 2/3 of what you were making for the rest of your life. So not the full amount of income that you were making, only 2/3 of it. That's if it's 100% disability, like for example, loss of limb or something like that, something very serious. If it's something less serious where you're not 100% permanently disabled, they'll make weekly payments to you for a certain period of time, but it ends, I think, around 106 weeks or something like that. So the benefits in workers' compensation cases are pretty limited, in my opinion, because they only compensate you for your loss of income and your loss of earning capacity. And we're going to see how this is very different than personal injury cases, which offer a lot of different things that are compensable. And your compensatory damages include things like pain and suffering, inconvenience, humiliation, emotional distress, all these subjective feelings that we experience when we have a serious injury are also things that monetary value needs to be assigned to. And we'll get into that in a little bit. So personal injury lawsuits, this is an area of law that is covered by torts. If you ever hear torts, it basically covers most civil lawsuits except for contract cases. Things like, there's civil assault, civil battery, intentional infliction of emotional distress, defamation, as we saw with the Johnny Depp trial. A tort is basically a cause of action. It's a legal basis to sue, right? If you say, hey, I want to go sue somebody, well, okay, what are you going to sue them for? That thing, that's called the cause of action. And in most personal injury cases, that's going to be negligence, sahlengari. So negligence means both, just the fact of negligence itself, but legally speaking, it's a cause of action that has 4 elements, which is duty of care, breach of duty, causation, and damages. So let's get into duty first. This is usually not an issue in most cases. We have a duty of care to behave as a reasonably prudent person when engaged in pretty much any daily activity in order to avoid harming others. That's the duty. Usually it's not an issue. In most car accident cases, it's, goes without saying that you have a duty to drive as a reasonably prudent person, not speed, not drink and drive, all of these things. Because if you do, you injure somebody, then you've breached your duty of care and you haven't acted like a reasonably prudent person. And it will subject you to a personal or to a lawsuit being filed against you. But the duty has 2 components. One is, you have a duty to behave a certain way. The other one is the standard of care, which is going to vary on the type of activity and circumstance. But it's important to note that you have anything that you're doing in your daily life, you should do it with care. Whether it's driving or whether it's you're a business owner, you have a duty to take reasonable care to ensure that your premises are safe for the customers and employees. If you're, if you own your house and there's certain dangers on your property that are not obvious to others, it's a latent danger, then you might have a responsibility to either warn your guests and even in some cases trespassers about the danger or just outright fixing it. Because a reasonably prudent person maintains their property in a way to avoid harm to others. So it's important to understand that in everything that you're doing. And, whether it's flowering, watering your flowers, let's say you live in an apartment and you're watering your flowers and all of a sudden one of the pots falls over and hits someone in the head. You could be sued for negligence, right? A tort, because you had a duty to water your plants responsibly without harming other people, and you failed to be careful enough. You breached your standard of care, and you could be sued for that, right? So something as basic as that. This also applies to riding a bicycle, anything you could think of. If you do it poorly, if you do it irresponsibly and negligently, you could be slapped with a personal injury lawsuit if you end up harming someone else. So this is just an example of breach. Breach, as I said, means when you fail to act like the fictitious reasonable person would under similar circumstances. So obviously, if a person drives straight through a red light the jury would find that they breached their duty of care, right? However, not every situation that results in harm to others is through negligence. Sometimes it's out of our control. For example, let's say there's a mechanical failure that made the brakes fail, and you had no reason to suspect that your car was brand new. You had just gotten it checked. Nobody told you that it had an issue with its brakes, and all of a sudden it has this weird malfunction that doesn't brake, and you run through the red light and injure somebody. Even though you've injured somebody, you might get hit with a personal injury civil lawsuit against you. Under these facts, you're not going to be held liable, right? Because you haven't breached your duty. You had no reason to suspect that this was going to happen, and it was a freak accident. So the damages, just quickly here, in a personal injury case, include the cost of your past medical bills, future medical bills, lost earnings, and loss of earning capacity. So already we can see that you're entitled to much more in a personal injury lawsuit, right? It's not even 2/3. Even in a workers' comp case, you can only get 2/3 of your lost earnings. In a personal injury case, you can get all of your lost earnings, plus the cost of your medical care. But really, it's about the non-economic damages. This is how you hear about these multi-million-dollar verdicts that attorneys get in certain cases. It's because of what we call non-economic or general damages, which means past and future physical pain. If you have an injury that you're going to have for the rest of your life, when a jury awards money, they have to reward enough money to compensate you for both what you've been through up to that point and also going into the future. Because you only get a one-time settlement, right, or a one-time verdict, and it has to account for everything, past and future. So past and future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, and emotional distress. If you ever go to a trial in a personal injury case, the best lawyers focus most of their closing argument to speak about general damages, right? They paint the picture of everything that the plaintiff's gone through. The pain of, not being able to sleep every night, waking up, having to go to the doctor all the time, being uncomfortable, not being able to sit for too long, not being able to do the activities that you used to do and you love to do that you can no longer do. So these are all things that the jury has to assign a monetary value to and award money damages, because we can't go back in time and undo the harm that has occurred to the plaintiff, right? This is the best system that we have, is to try to compensate people, is to try to assign monetary value to it. One thing that's really important, and I'm sure everybody here knows the importance of having car insurance, but for people who don't have valid car insurance, either because you didn't purchase it, or let's say you forgot to make payments and it's invalid, the California legislator has said that if you get into an accident and it's someone else's fault, but you didn't have valid driver's liability insurance, you won't be able to recover general damages in a personal injury lawsuit. The only thing that you can recover are your economic damages, which include the costs of your medical treatment and your lost earnings. You can't be compensated for your pain and suffering and so forth. Damages in a wrongful death case. Wrongful death case is the same thing as a negligence case, but instead of someone being injured, it's when someone actually died and their heir, whoever their next of kin is, it could be, usually it's the surviving spouse or the surviving kids, they can bring a claim for wrongful death against the at-fault party, and they're entitled to recover economic damages as well, referred to as special damages, cost of funeral, burial. But really the biggest thing that you can get compensated for is the loss of the decedent's love, companionship, comfort, care, assistance, protection, affection, society, and moral support. So essentially, the jury has to figure out what the loss of that person means to the surviving family member, right? And not how much that person's life was worth. It doesn't matter if that person was making, $1 million a year. If they didn't have a good relationship with their son, if they hadn't seen their son, for 5 years, or talk to each other on their birthdays or travel together, then that's not going to be a very strong claim, right? Because this is how you try to ascribe value to a case like this. But obviously in a case where somebody loses their young child, and we had a case like this actually, where our client lost her 14-year-old son in a tragic car accident. And unfortunately, it was only a $2 million insurance policy. So that was the maximum that she could recover in that situation. And the dad of the boy also had a claim, but he was not in the picture. He wasn't paying child support. He wasn't raising the son who passed away tragically. So out of the $2 million settlement, the mom, who was our client, got 1.7 million, and the dad only got 300. And the reason for that was exactly this. The dad couldn't prove to the same extent that the mom could that he lost his son's love, companionship, comfort, and care, for the remainder of his lifespan. So those are the damages when it comes to personal injury and wrongful death lawsuits. I think I'm running out of time here, so I'm just going to skip to my recommendation here that I think everybody should consider this very seriously. In California, when you buy car insurance, legally, you only have to buy liability insurance, which means that if you're in an accident and it's your fault, then your own insurance, if you get sued, your insurance will cover the cost of that person's damages, right? But what happens when, if you get into an accident and it's not your fault, and the person only has $15,000 minimum policy, right? Because that's the minimum policy that's required in California. They only have to have 15,000. Let's say you get into a very bad accident, you require surgery or extensive treatment. The cost of your medical treatment is going to be far, far more than 15,000. So what uninsured motorist coverage and underinsured is, in situations like that, if you get into an accident with someone who either doesn't have insurance or they have minimum policy, this coverage will kick in to provide the difference. So let's say you get into an accident with somebody who has a $15,000 minimum policy. You have $100,000 in medical bills. You've unfortunately had to get surgery. If you have underinsured motorist coverage in the amount of 100,000, then you're entitled to the offset. So you can get $85,000 from your own insurance company. This is really, really important. And this is the best way that you can protect yourself. When you're getting liability insurance, you're really just, of course, you're abiding by the law, but you're really just protecting other people that you might harm through your negligence. If you want to really protect yourself from people who don't have insurance and who might, God forbid, get into an accident with you, or people who have minimum policy, you should absolutely look into, call your insurance company and say, I want uninsured motorists or underinsured motorist coverage. And I would get the liability limit should be at least 100,000 per person, 300,000 per accident. If you can get more, great. And the cost of this is only $20 to $30 more a month, and it's absolutely worth it. This is very sad. Even sometimes when people die in car accidents, the person who's at fault might only have 15,000 car insurance. And that's all, a surviving spouse or surviving kids could get, because most people are judgment proof. They're living paycheck to paycheck. You can go get $1 million judgment, but you may not be able to ever recover that against the person. So it's very important to get the UIM. And that would be my biggest recommendation. If I didn't leave you guys with anything else tonight, that would be the most important thing. So I'm going to spend some time answering questions. I can go until 8:30 if people have questions, but otherwise, thank you for listening and your attention.
Thank you very much. Thank you. It was an eye-opener, what we can allow or not allow for the police.
Thank you very much, everybody. مرسی از همگی. شب همگی بخیر. مرسی از توجهتون و ببخشید اگر
Thank you very much. Thank you very much. It seems like we need to invite you again.
مرسی دکتر مدنی. شب همگی بخیر.
خواهش میکنم.
خدا.
مرسی. It's good to know you. ولی انشالله که personally we don't need you ولی it's good to know you. خیلی
ایشالله.
خیلی ممنون.
خیلی ممنون.
ممنون. مرسی.